they could. So getting that going, and then we'll get started. All right, let's be on the record in case number 2018CR1001, captioned State of Kansas versus Joseph Edward Williams. Would the parties announce their appearances, please?
May it please the court, State of Kansas appears by Assistant District Attorney Nicholas Campbell.
May it please the court, Jack West on behalf of Mr. Williams, who appears by video, as do we all.
All right, Mr. Williams, we're doing this sentencing here today by video conference because of the pandemic and the fact that the court's physical location is closed. My understanding is you talked to Mr. West about this. You understand that if you wanted to appear personally in court, you would have that right, but you're waiving it today and agreeing to proceed by video conference. Is that correct?
Correct.
All right, thank you. All right, as I said, we're here set down for sentencing. This case was originally set for sentencing last year, it looks like. At that time, the defendant did not appear for the sentencing date. A bench warrant was issued. He was picked up for on that warrant shortly before the courts closed down. At that time, he was set for sentencing on March 27th, but the courts were closed at that time. I granted the defendant's motion for immediate release, given the fact of the pandemic and frankly, the court's assessment that Mr. Williams was not charged with a violent crime or had violent criminal history. Therefore, I deemed it in the public's best interest as well as his own to be released. I gave him an OR bond and we set sentencing down for today. I've received the PSI in this case. The critical findings are as follows. The sole count of conviction is one of attempted burglary, which is a severity level 10 non-person felony. The defendant's criminal history score was found to be that of C. That would leave him normally with a presumption. He doesn't have a presumption because of special rule number 10, which is crime committed while on felony bond. Without a presumption, his underlying presumed range is 9, 10, or 11 months in the Department of Corrections. If he has to do that time, he'll be subject to or eligible for up to 20% good time credit and subject to a post-release supervision duration of 12 months. If he's granted probation today, it will be for a period of 12 months to community corrections. First, Mr. Campbell, I'd ask you, did you have an opportunity to review the PSI? Do you have any additions, corrections, or challenges to the finding therein?
Your Honor, I do not have any objections.
Mr. West, same question.
No objections, Your Honor. I've discussed the report with my client and he has no objections.
All right. Mr. Williams, what your lawyer's telling me is he went over this PSI that I just talked about. It's not showing up on camera. That had those findings that I just talked about. Specifically, what I want to make sure he went over with you was that the conviction was the attempted burglary and that criminal history worksheet in the back that shows your former contacts with courts. I would ask you if you've had an opportunity to go over all of that with Mr. West and if you have any challenges to the findings therein.
I've went over with him and I have no challenges.
All right, thank you. I will adopt the findings of the PSI for purposes of this hearing. Mr. West, you filed a motion for downward dispositional departure. Would you like to be heard on that this afternoon?
Yes, Your Honor. In addition to that motion, Mr. Williams has a good job now. He works for a roofing company. He's living with his mom. He wants to get a good solid footing underneath him before he moves out. He also has 3 children. He enjoys hanging out with them and doing stuff with them. He gets a chance to see them whenever he wants to, as well as every other weekend. He is actually on a very good track, Your Honor. I think a probation is very appropriate in this instance. He's had no problems while he's been released. I think he's a great candidate for probation, Judge.
All right. Mr. West, can you enlighten me? Do you know, have you discussed with your client why he wasn't there for his sentencing last May?
Yes, Your Honor. Between being scared and resorting to old ways, he fell back into some bad habits rather quickly. However, having been out since you released him, he has genuinely changed his ways. He seems like a different person now than when I've spoken with him in the past.
Thank you. All right. Mr. Campbell, any comments as to sentencing?
Yes, Your Honor. Sorry. Issues with my computer. Okay, sorry. Yes. We would ask that you follow the plea agreement in this case. We do not have any objection to probation. However, because he failed to appear at the last hearing, we would ask that you sentence him to the aggravated term for his underlying sentence.
Thank you. And before I get to the sentencing here and asking Mr. Campbell what he has to say, it looks like the victim requested, what was it, $3,500 in restitution? Is that correct, Mr. Campbell?
I believe so, yes, Your Honor.
I want to look. I can't remember if it's 35 or 36. $3,500. Mr. West, you or your client going to have any objection to that?
No, Your Honor, we understand that it may be imposed jointly and severally, and he may be completely responsible for it ultimately.
All right. All right. Mr. Williams, now is your opportunity to tell me anything you want me to know in mitigation of your sentence today.
I'm just changed. I'd appreciate the chance to continue doing what I'm doing now. I work every day now. Like Mr. West said, I have my kids every other weekend. I see them whenever I want. I'm helping my mother. It took me a long time to get here, but I'm here.
All right. Thank you. Mr. West, you know any legal reason why I should not now proceed to sentencing?
No, Your Honor.
All right. Well, I can tell you this one is a little bit more difficult for me to follow the agreement than normal. I'm not going to keep you in suspense. I'm going to follow the agreement. But frankly, the state is kind of showing even more restraint because part of the plea agreement, as I read it, was that the defendant would show up for all of his court hearings after the plea, which of course he didn't. And he was on absconder status for almost a full year before he was picked up and brought over here. So look, I don't doubt what you're telling me, Mr. Williams, that you're seeing a better way and that you're doing that since you've been out. But let's face it, that's a pretty short, yes, Mr. West.
I'll address that when you're finished or whenever you want me to, Judge.
Go right ahead.
He was also picked up in Clay County, and he spent some time in DOC, correct, Joey?
Yeah, the Department of Corrections, 10 months in Missouri DOC.
All right. So were you in custody when that sentencing happened or
I was not.
supposed to?
I was not.
All right. All right. Thank you, Mr. West. All right. So look, you would have to agree with me that this time that the leaf has been turned over has been pretty short. I think it was, I don't know, 3 or 4 weeks ago that I let you out of jail. It looks like going back to 1998, your biggest problem has been keeping your hands off of other people's stuff. Almost all of these crimes appear to be somewhere between, either involving a theft or a burglary or crimes that kind of circle around those kind of things. So I need to put it this way. I think the state's being awful kind in not asking for more than just an extra month on the sentence. And I think the court's being pretty generous in following this whole thing. But I'm not going to have any problem making sure you do every day of your sentence if you find yourself in trouble again while on this. If you're breaking other parts of it, We'll look at it. We'll see what you do. I expect compliance, but frankly, if you're picked up again in somebody else's car or in somebody else's house, or they find somebody's property in your house, then it's going to be all over. So I don't know how to make that any more clear. It's been 1998 was the first adult conviction that I see for a theft or light crime. And it's been, I won't say consistent, but persistent for sure through, 2019. So I need you to understand this. You're entitled to a hearing if you get another case, but I can tell you this, it's going to be a short hearing. So I urge you to do all the things in your probation, but specifically don't break any more laws. Don't take any more property that's not yours, or it's going to be a quick trip to the prison. You understand that?
Yes, sir.
All right. So for the sole count of conviction, attempted burglary, a severity level 10, non-person felony, the defendant will be sentenced to the aggravated term of 11 months. If he has to do that time, he'll be eligible for 20% good time credit and subject to 12 months of post-release supervision. His application for probation is considered, and it is granted to community corrections for a period of 12 months. It will be the standard terms of probation, and part of that, the terms though specifically will be that the restitution amount of $3,500 to the victim is hereby ordered. The defendant and his attorney have indicated that Mr. Williams is gainfully employed, and which sounds like a good job. So I think a payment plan of $200 a month until he gets that paid off should be appropriate. Obviously, if he wants it to finish before his probation is due to expire, he may have to make more payments than that. I'll leave that up to him. But at a minimum, $200 a month. All right, let's look at some of the other stuff in here as far as costs and fees go. There is a court cost of $193, supervision fee of $120. Those are both imposed. Mr. West is retained, so there is no attorney fee on that. Is this Mr. Williams' first Kansas felony conviction?
I know we had a case out in Johnson County, correct? Was that a felony?
Yes.
All right.
Yes, I see that from 2008. That would have been since they've been taking DNA samples. So I'm going to find that his DNA is currently on file and there's no need to do that. As I said, $3,500 in restitution to the victim is ordered. And I think though there won't be any fine. And I think that is all of the costs and fees. All right. Mr. Williams, you have 14 days from today to appeal anything you don't like about your sentence. You also have the right to seek expungement of your sentence, of your conviction, after a period of time following successful completion of probation. As a convicted felon, it's prohibited for you to own or possess a firearm and certain kind of deadly cutting instruments like dirks, daggers, switchblades, basically any knife that can be considered a deadly weapon. The point being, Mr. West can tell you more about that. The point being, before you decide to own or possess any kind of weapon like that, make sure you talk to a good lawyer like Mr. West to make sure that it wouldn't be reason to revoke your probation or add new charges, okay?
Yes, sir.
All right. Mr. Campbell, anything that, jail time credit,
I have 106 days, Your Honor.
you agree with that, Mr. West?
I was trying to add that up earlier. Right now, I cannot dispute that. I think it's at least 106 days, yeah.
He'll be entitled to that credit. Make sure you guys agree on that and then get it in that order. All right. Pardon, yes.
One last thing, I would ask, this is a border box, or not, sorry, border box. It's a special rule 10 case committed while on felony bond. We would ask that this case run consecutive to his other case, and I can give that case number when Your Honor's ready.
And that is a Kansas case or not?
I believe it's Missouri.
Okay, so I don't know that the special rule calls for mandatory, well, it does, a mandatory no, I'm sorry. It calls for mandatory consecutive to a Kansas case. It destroys the presumption no matter where the case is from. So I don't think it's mandatory, but even if it's not mandatory, are you still requesting consecutive?
Correct. Special Rule 10 is not mandatory for consecutive. It's discretionary with the judge. We would ask that it run consecutive.
All right. Mr. West, comments on that?
Which case are we talking about?
The Missouri, I believe it's the Clay County case that he was shown to be on bond for when this crime was committed.
And I believe the case number is 18CR101063, which is on the PSI.
1816 would be a Jackson County case.
I think it wasn't it the 19 CYCR 0114?
That's the one that he was sentenced on.
Okay. Let me, all right, let me find this.
And I'm just going off the
yeah.
PSI.
I see this, it's the 1816-CR 01063, and it is a Jackson County case. If you look at the page right in front of the criminal history worksheet, or the first page of the worksheet, halfway down where it says other felony bond.
Yes, Judge. Okay.
Okay. All right.
Yes, and yes, that one is pending. That is correct.
All right. So is there no sentence for me to run that consecutive to yet?
That's correct, Judge.
Mr. Campbell, what's your understanding of how I handled that? If there's not a sentence now, it's up to that court that sentences later whether to make it consecutive to mine or not. Isn't that correct?
Your Honor, that is correct. And so I would not ask them at that point run consecutive. I thought this was the one that he had already gone over for and been sentenced. So I apologize for that.
All right. Okay. And what is his status on the Clay County tampering case? Is he on supervision in Missouri for that?
Joey, you are on supervision still, aren't you?
Yes, I'm on parole in Missouri off of that case.
All right. All right. So it looks like the only active case that he has, only active sentence is that Clay County 19 CYCR 114 case.
When you say active, Judge?
Active sentence where the other case is predisposition.
The Jackson County case is predisposition, yes, Judge.
Okay. I am going to order that this sentence, I understand that I have discretion, but I'm going to order this sentence run consecutive to the Clay County case 19 CYCR 114. The other case doesn't have a sentence, so I can't run it consecutive. I don't know, Mr. Williams, do you know what your backup time is on that Clay County case?
I have roughly 3 more years to do on parole.
All right. So look, if I ran it concurrent, I don't think there's any kind of hammer on you about this case. That's why I'm running it consecutive, because I think you need to understand that not if you decide or if you fall back into your old ways, as your attorney put it, that not only are you going to have to answer to them, but to us as well. All right. Folks, Mr. Campbell, again, first, does that cover everything?
I believe so, Your Honor.
Mr. West?
Your Honor, we have one other matter. Mr. Williams, Wyandotte County pretrial services officer wanted him to get authorization from you to allow him to travel to, I believe, Baylor, Kansas for
No.
work next. I'm sorry, what?
Emporia, Kansas.
Emporia, Kansas. Next week. It's going to be a week-long job, Joey.
Tuesday to Friday.
Okay.
Wanted to get authorization from you.
Who's supervising you over there at pretrial?
Hold on. It would be, that would be Katrina. I don't know her last name. Katrina.
Carrillo.
Yes, that's
All right.
her.
I will send her I am authorizing your travel to Emporia for work. I
Thank
will send her an email letting her know that.
Okay, thank you.
Here's what I need you to do, Mr. Williams. When we're done here, I want you to call this number. It's for community corrections. It's 913-573-4180.
Okay.
They will take your phone call and they will instruct you how to, I think what they're doing right now is doing phone intakes and phone supervision until they begin seeing people again, which should be in the next couple of weeks.
Okay.
All right. So I need you to call them before today's up to make
I'm
sure
gonna do it.
that you're checked. You might get a voicemail. If you do, give them your name, your case number, how to get back to you. Okay.
Yes, sir.
All right. Anything else for our record today?
Nothing for the record, but one thing after we go off the record.
All right.
Nothing on behalf of Mr. Williams, Judge.
All right. We're going to adjourn our hearing. I'll stop the live stream.